Hi, everyone. My name is Marvell Faulkner. I'm an attorney with the Legal Aid Foundation of Los Angeles. Today, we'll be going over tenants' rights after a disaster, and this is presented by LAFLA and Stay Housed LA. Okay, so in this presentation, we'll cover one, your rights as a tenant if your home was completely destroyed. Two, the landlord's duty of habitability. Three, your rights as a tenant if your home was damaged but repairable. And four, some post-disaster legal protections that may apply to you. Tenants' rights in completely destroyed homes. So unless your lease says otherwise, if your unit was fully destroyed, your tenancy has ended and you do not owe rent. Your landlord must return the unused portion of January's rent payment and the security deposit. The deposit must be returned within 3 weeks. If you are behind on rent, the landlord can deduct old rent from the security deposit. There is no clear definition of destroyed, so you'd want to consult your local housing department. So unless your lease says otherwise, the landlord is not required to pay relocation assistance under state law, but you want to confirm with your local housing department to see if you are owed any relocation under your local ordinance. And I'll talk more on local ordinances later. Now we're going to switch gears to the landlord's duty, which is the implied warranty of habitability. So landlords have a duty to maintain a rented property in a safe condition. This is under the Green versus Superior Court case, but also in the California Civil Code. This duty is implied in every rental agreement, and it cannot be waived by the tenant. A habitable unit must substantially satisfy all of the following conditions. It must have a waterproof roof and walls. The windows and doors must be unbroken. It must have working plumbing and gas. It must have hot and cold running water, a working sewage disposal system, working heating equipment, and working electrical lighting and wiring. So habitability after a disaster. If a tenant's unit is not completely destroyed, the landlord has a duty to fix the property. If the landlord does not fix the property within a reasonable time after a tenant provides notice to the landlord of the needed repairs, the tenant has a right to end the lease agreement. When the unit does not conform to housing codes and the defects are correctable, the tenant is only liable for the value of the property in its defective condition. Currently, in the city of LA, tenants cannot be evicted due to substantial remodels of their rental unit. Now we're switching gears to tenants' rights in homes with minor damage. These are often the green and yellow tagged homes. So if your home was lightly damaged, but still safe for living, your tenancy is still valid and you still owe rent. You can live there while repairs are being made and or after they're completed. Tenants may be entitled to a rent reduction during bad conditions, but still should pay full rent unless they have a written agreement with their landlord. You should document any substandard living conditions. Put all repair requests to the landlord in writing and keep all records. The landlord is obligated to maintain the safety and habitability of the unit. You may be able to negotiate a rent reduction with your landlord for housing conditions or lack of full use of the unit. If you do that, then everything like above should be in writing and you should keep all records. If you withhold rent without an agreement, you run the risk of getting an eviction notice. So tenants should seek remedy through local rent board or small claims court. Even if your home can be repaired, the landlord may be able to serve you with a legal eviction notice. So your landlord may ask you to leave to make major repairs or renovations. In most cases, the landlord will have to pay you relocation money to leave. The amount you are owed will depend on whether you are subject to a local ordinance or a state law. You would also be entitled to proper written notice, which is usually 30 or 60-day notice. If you receive an eviction notice, you should call State House LA or a local legal services provider as soon as possible. So if your home had minor damage, but you want to leave your unit, you should provide at least 30 days notice or the notice required by your lease. If you want to leave in the middle of your lease, you should try to find a replacement tenant. Your landlord may be able to hold you responsible for unpaid rent under the lease if notice is not provided or there is no replacement tenant. If your home had minor damage and you want to leave your unit, you may be entitled to break your lease agreement if the landlord refuses to pay to repair your unit. Make sure to fully document all conditions and all of your requests and provide an opportunity for the landlord to repair the issues. And we're going to switch gears and talk about tenants' rights in severely damaged homes, which are often the red tagged homes. So if your home was severely damaged due to the wildfire disaster, including properties red tagged by the government, your lease still exists. Generally, you may choose to end your lease or return to your rental unit after repairs are made. You should communicate your decision to your landlord in writing and keep all records. A building code enforcement agency through the city or the county could order you to move out because your home is unsafe. In some cases, the landlord will have to pay you relocation assistance. The amount depends on whether you are subject to a local ordinance or a state law. If you decide to end your lease, your landlord must return your security deposit within 3 weeks. They also must return the unused portion of January's rent. And if you are behind on rent, the landlord can deduct old rent from that security deposit. If you decide to return to your rental unit, the landlord is responsible for making necessary repairs to ensure the home is in a safe, livable condition. You have the right to return to a repaired home, but you do not owe rent while the home is fully uninhabitable. After repairs are complete, you must resume paying the rent. So severely damaged homes in unincorporated LA County, which includes the Altadena area. So if your damaged home is not subject to the LA County Rent Stabilization and Tenant Protection Ordinance, you are not eligible for relocation assistance. But you should save all of your receipts for related expenses because you may be eligible for reimbursement through FEMA or other resources out there. If you intend to return to your unit after it is repaired, make sure you notify your landlord in writing and keep all records. If your home is in unincorporated Los Angeles County and it is covered by the Rent Stabilization and Tenant Protection Ordinance, and you are displaced due to the damages of your unit, you may be eligible for temporary or permanent relocation assistance. It just depends on your situation. So if you are displaced for 30 days or less, you are eligible for per diem, which is an allowance or payment made each month for lodging, food, and incidentals from your landlord. If your landlord relocates you to a hotel or motel, the accommodations must be safe and sanitary. You are still obligated to pay rent while you are temporarily displaced. If you are displaced for 31 days or more, your landlord may need to provide a per diem for lodging, food, or incidentals, or temporary accommodations that are comparable to the home you were displaced from. You are still obligated to pay rent while you're temporarily displaced. Severely damaged homes in the city of Pasadena. If your home is not subject to Pasadena's rent stabilization ordinance, you are not eligible for any relocation assistance from your landlord. You may be eligible for assistance from other resources like FEMA. So again, be sure to keep all of your receipts and all records. You are covered by the Pasadena Rent Stabilization Ordinance, and you are displaced for 30 days or more for necessary and substantial repairs. You may have three important rights. First, the right of first refusal of any comparable vacant unit owned by your landlord at the same or lower rent. Two, the right to return to the unit at the same rent price. And three, you may also be eligible for relocation assistance. If you are eligible for relocation assistance, your landlord must pay you 50% of the required relocation assistance within 10 days of serving you with a notice of termination of your tenancy to make repairs. The landlord must pay the remainder of the funds and put them into an escrow account at least 28 days prior to the end of the notice. If the landlord does not place the funds in an escrow account, they must be paid to you upon confirmation that you are vacating the unit. Severely damaged homes in the city of Los Angeles. If your home is in the city of LA and not protected by rent stabilization ordinance or just cause ordinance, your landlord does not have to pay relocation assistance. If your home was severely damaged, save receipts for related expenses because you may be eligible for reimbursement through FEMA and other resources. If you intend to return to your home after it is repaired, notify your landlord in writing and keep a copy of all of your records. If your home is subject to the rent stabilization or just cause ordinances in the city of LA and is partially damaged, one, your tenancy is protected and you have a right to return to your unit. Your landlord must your landlord may owe relocation assistance depending on what is done with the property and when. Permanent relocation if the unit is demolished or converted. It may be temporary or permanent relocation if the unit is repaired, and the city will review the status of any specific building on a case-by-case basis. Okay, so now we're going to switch gears into new disaster-related tenant protections that may apply to you. So this first one is about hosting fire survivors. So the state issued an order prohibiting evictions based on tenants allowing displaced fire victims, only people, to live with them, even if their lease prohibits additional tenants. This order was in effect until March 8th, 2025. The city and the county of LA are also prohibiting evictions based on tenants allowing displaced fire victims and pets to live with them, even if their lease prohibits additional tenants or pets. This order is in effect until May 31st, 2026, unless it's repealed sooner. All right, limited eviction moratorium. So on February 25th, 2025, the County of LA passed a new law for all of LA County that temporarily bans evictions for non-payment of rent for rent due from February 2025 to July 31st, 2025, if one, the tenant's household income is less than 150% AMI, which is less than $103,000 for one person and $147,300 for four people. And the tenant signs a writing that swears that the tenant lost at least 10% of their income due to the wildfires. They are enrolled in a wildfire relief program, unemployment, or seeking employment. The tenant must send the landlord this writing within 7 days of rent due each month. The tenant must also pay back rent until July 31st, 2026, which is 12 months after the expiration of this protection. So this is a very helpful link to the form. The Department of Consumer and Business Affairs released this self-attestation and an FAQ on the new temporary eviction protections for tenants who were directly financially impacted from job loss or lost more than 10% of their wages. So there are some protections against price gouging under the California Penal Code, Section 396. It protects consumers against price gouging during times of an emergency. It prohibits price increases of more than 10% higher than pre-disaster rates. This covers rental housing, hotel accommodations, repair costs, and other essential consumer goods and services. It also prohibits evictions to lease to another tenant for higher rent. So in some eviction cases, it acts as a defense. All right, so some rent stabilization ordinances. The landlord cannot raise rent over allowable rent stabilization ordinance limits. The city of LA's limit, rent increases are capped at 4%. In unincorporated LA County, rent increases are capped at 2.565 through 3.565% for small landlords. And in Pasadena, rent increases are capped at 3%. And here's a page on some more tenant resources. First, there's stayhousedla.org and the number, which is a very helpful website to help understand your rights, and also has a lot of presentations and workshop listings on there. Um, Other stay housed LA legal orgs that are servicing your area depends on which area you're in. For the Altadena and Pasadena area, there's neighborhood legal services. For the Pacific Palisades and Santa Monica, there's the Legal Aid Foundation of Los Angeles. And for the city of LA, there's the Legal Aid Foundation of Los Angeles and the Inner City Law Center. And that concludes our presentation on tenants' rights after a disaster. Again, for more resources, please feel free to reach out to any of these legal orgs or the Stay Housed LA website. Thank you.